Hello again, and welcome to the second of these lectures on Unit 1. So we're looking at key corporate law concepts in this unit, and as you recall in the last lecture we talked about separate legal personality and the consequences of separate legal personality, and in particular we looked in some detail at the case of Salomon and Salomon. And I said that that was very much the foundation of modern UK corporate law. Well, today we're going to be looking at, in this presentation, some weaknesses in the principle. We will be looking at some criticisms of the principle, and we'll also be looking at situations where the courts might actually ignore separate legal personality and treat those behind the company as the same as the company. So, learning outcomes for this session are to identify the consequences of separate legal personality. So, what are the practical consequences arising from a company's separate legal personality? And then we'll look at the exceptions to it, in particular what the courts call lifting or piercing the corporate veil. So, Salomon and Salomon. Key case, clearly very influential on the development of UK company law, but not universally popular with commentators, with academics. In particular, there was a very influential article written by a legal academic by the name of Otto Kahn-Freund back in 1994 in the Modern Law Review. And he made a detailed critique of the decision. In particular, what he was concerned with was the fact that the decision in Salomon and Salomon really failed to provide adequate protection to creditors, to people that a company owed money to. So what Kahn-Freund was critiquing was the fact that the company structure, and in particular the concept of limited liability, the fact that those behind the company not only are treated as separate legal entities from the company, but also will have only limited, and in many cases virtually no, liability for company debts. He was arguing that this was essentially unbalancing the relationship between companies and their creditors. His argument was that this was unfair, that those doing business with a company were at risk of losing out if a company went bust. So he went as far as to actually describe the decision in Salomon and Salomon as a calamitous decision. So it's a very powerful argument, and I think it encapsulates the problems, certainly, with treating a company as a separate legal entity, because it does mean that if you enter into a contract with a limited company, then you always have to bear in mind the risk that if the company breaks that contract and ends up owing you money, then there's a strong likelihood, a strong possibility that you won't get your money back. And of course you can't make the owners of the company or the directors of the company personally liable for that debt. So certainly Kahn-Freund had a point. He was quite correct in saying that for creditors at least, for people owed money by companies, the decision in Salomon and Salomon could indeed have calamitous consequences. However, other academics, and I've given you two other articles that you could take a look at, that by Pickering in 1968 and Grantham in 1998, have argued that the balance is just about right, that the benefit to business and society of the limited company as a separate legal entity outweighs the risk to individual creditors. In particular, by allowing people to make use of the company structure and the limited liability that it provides, it very much encourages people to take risks. It encourages people to invest in business. And without that protection, it would be a much riskier thing to do to invest in a new business, and therefore it would likely deter many people from becoming entrepreneurs. So there are very much two schools of thought, but the latter school of thought has been the most influential. And indeed, as Pickering and Grantham have pointed out, it's not that creditors of companies have absolutely no protection at all. As we'll see, the courts have, over the years, developed some protection for creditors. And this is what we call lifting or piercing the corporate veil. In other words, the courts have developed or identified certain circumstances in which they will ignore the separate legal personality of the company. So before we look at the situations where the courts will lift the corporate veil, just some things for you to think about, some questions for you to have a think about. So firstly, think about what we actually mean by the doctrine of separate legal personality. Also think about why was the House of Lords decision in Salomon so important? And also think about what are the main advantages of separate personality and what are the main problems associated with it. So it might be good for you to spend some time researching this and seeing what arguments you can find for both in terms of the advantages and the disadvantages. It just gets you to think a little bit about the basic principles behind corporate law. So what are the consequences of separate legal personality? It's something that we talk a lot about and we say that it's a fundamental principle, but in practical terms, what does it actually mean? Well, I think we can illustrate this quite well by reference to a couple of cases. So first of all, Macora and Northern Insurance back in 1925. In this case, Mr. Macora owned a forestry estate in Ireland, and so it was a business in that he grew forestry, grew timber in order to sell it to the commercial market. He'd been running this business for some years, and then he decided to incorporate it as a company. So he formed a company and transferred the forestry business to the company. Unfortunately, what happened was that there was a major fire on the estate and much of the commercial timber was destroyed. Mr. Macora wasn't too worried, however, because he knew that he had insurance. He'd taken out an insurance policy with Northern Insurance, and he therefore assumed that the insurance company would pay out, so he'd recoup his losses. Unfortunately, the fatal mistake that Mr. Macora had made was that he'd taken out the insurance policy in his own personal name, not in the name of the company. So Northern Insurance refused to pay out. Mr. Macora went to court to try and force Northern Insurance to pay out, but the courts agreed with the insurance company. They said that essentially Mr. Macora had no insurable interest. The timber that had been destroyed by fire was owned by the company, and therefore only the company had an insurable interest. Mr. Macora had made a fatal mistake by taking out the policy in his own name. So that was a very unfortunate consequence. It shows that the company can clearly own its own property, which sometimes, as in Mr. Macora's case, can be rather unfortunate. However, there can also be beneficial consequences of the fact that the company is a separate legal personality. And we can see that from the case of Lee versus Lee's Air Farming. This is actually a case which took place in New Zealand and went through the New Zealand courts before coming to the Privy Council in the UK. So it's not directly UK law, but it is based on a very similar New Zealand law. So what happened here was that Mr. Lee was a pilot, and he set up a company called Lee's Air Farming. And he was the main shareholder in the company. He also was the only director of the company, and he was an employee of the company. He was the company's pilot. Sadly, Mr. Lee died in a plane crash whilst on company business, and his widow, Catherine, applied for compensation from the New Zealand government under their Workers' Compensation Act. The government refused to pay out because they said that Mr. Lee was not a worker, he was not an employee of the company, because essentially the company and he were one and the same. So similar arguments to those that were tried in Makora and indeed in Salomon and Salomon. As I said, the case reached the Privy Council in the UK, and the Privy Council found in favour of Mrs. Lee. They said that because the company had been properly registered, properly incorporated, it was an entirely separate legal entity from Mr. Lee himself. And therefore, even though he was the director of the company, he was the major shareholder in the company, there was absolutely no reason why he couldn't also be an employee of the company. Because as an employee, he was acting in an entirely different capacity. He was still a separate person from the company. Therefore, he was a worker, and Mrs. Lee could claim on the Workers' Compensation Fund. So clearly, separate legal personality has consequences. And for creditors, as Freund identified, when combined with the principle of limited liability, the fact that members are not fully liable for the debts of the company that they own, this can clearly have very serious consequences for someone owed money by a company that becomes insolvent. It also means that the company can be, if you like, misused. There is a risk that a company could be used to hide the true facts, to try and protect an individual from some kind of legal liability. Therefore, the courts have developed a range of principles, a range of situations where they are prepared to what's called lift the corporate veil. Sometimes it's called lifting the corporate veil, sometimes it's called piercing the corporate veil. But essentially, what this refers to is situations where the courts in particular, but sometimes also the government via an Act of Parliament, have decided that the separation of the company from the individual should not be maintained. Some of the case law on this is quite conflicting, and it's actually not that easy always to identify clear principles as to when the courts will indeed lift or pierce the corporate veil. But we'll look at some of the cases and we'll try as best we can to identify some principles that can be applied. A very useful case was the Court of Appeal decision in Adams and Cape Industries in 1990. Be a good case for you to have a look at. See if you can find a report on the case. Google is often a good way of finding case reports, but certainly it's one that's referred to in all the textbooks as well. So what happened here, very, very briefly, is that a US subsidiary of Cape Industries ran an asbestos operation in the US. Now, lots of the workers of this US subsidiary got asbestosis, and they sought to bring a claim against the company for compensation. the US subsidiary company was wound up. And so although they were successful in bringing a claim against that company, the company no longer existed. And so they sought to enforce their US judgment against Cape Industries in the UK courts. And so in deciding this case, the Court of Appeal reviewed the previous cases on lifting the corporate veil, and they tried to identify principles. And they essentially identified three situations, three circumstances in which the courts would, in their opinion, lift the corporate veil and treat the company and those behind the company as one and the same. And so there were three situations. Firstly, where there is a statute that allows corporate personality to be ignored. Secondly, where the company is merely a facade, a fraud. And thirdly, where you have a corporate group of companies and the subsidiary is merely acting as an agent for the holding company. The court in Adams and Cape Industries referred to a number of previous cases on each of these situations. So in terms of statute, they weren't relevant in that particular case. There are, under the Companies Act and under the Insolvency Act, a variety of situations in which the separate legal personality of a company can be ignored. So if a company becomes insolvent and there has been some kind of wrongful trading or indeed fraudulent trading by those behind the company, then those persons can be made personally liable for the company's debts. But clearly that wasn't the case here. So what the court in Adams was more interested in was in looking at what they identified as fraud cases, and particularly relevant on the facts of Adams and Cape Industries was those cases involving groups of companies. So looking at the second category which they identified, fraud or facade cases, to look at a couple of early cases to illustrate this. Re-FG Films in 1953, the court refused to treat a company as a separate entity where the company had been set up purely to get around laws on the subsidies that were being granted to UK filmmakers. So essentially what happened, a US film company wanted to take advantage of government subsidies that were being given to British film companies, so they set up a British subsidiary. The court said that the British subsidiary had simply been set up as a fraud or facade to hide the true facts, and therefore the US company could not benefit from those subsidies. Similarly, Guildford Motor Company and Horn, Mr. Horn tried to avoid a restrictive covenant in his employment contract by setting up his own company. So essentially he left his employer. There was a restrictive covenant in his employment contract which prevented him from canvassing business from former customers, and he sought to get around this by setting up his own company. And again, the court said that the company was being used merely as a facade, and found that Mr. Horn was indeed liable. Jones and Littman, similar case where one of the parties to a contract for the sale of land tried to avoid liability by transferring the land to a subsidiary company. Again, that failed. The other cases on this slide involve groups of companies. So Smithstone and Knight versus Birmingham Corporation was a case involving the law on compulsory purchase of land. And the court in that case, really for the first time, decided that a subsidiary company in a group of companies could be treated as an agent on behalf of the parent company, the holding company. This was then developed by Lord Denning in the DHN food distributors case in 1976, where he essentially created a new principle whereby if a group, if a subsidiary company is acting on behalf of its parent company, if in his words it can be said to be a single economic entity, then the parent company and the subsidiary company can be treated as one and the same thing. So essentially said that where the parent company is acting as the head and brains of the subsidiary company, then the two companies will be treated as the same rather than as separate legal personalities. As with a lot of Lord Denning's decisions, this one was not entirely approved of. It wasn't directly overruled, but the House of Lords in Wolfson and Strathclyde Regional Council really doubted the validity of this concept of the single economic entity. So in Adams versus Cape Industries itself, the court actually found in favour of Cape Industries, and they adopted the limited view of the House of Lords in Wolfson, and so the subsidiary company wasn't held to have been acting as an agent on behalf of Cape Industries, the parent company. Other more recent cases, well, Creasy and Breachwood Motors for a time seemed to have extended the possibility for a subsidiary company or members in a group of companies to be treated as one and the same, in that it allowed a former employee to sue the parent company for arrears of salary that he was owed by the subsidiary company, which had subsequently gone bust. But again, Nord versus Belhaven Pubs, in a similar scenario, the court doubted the correctness of that decision. All of this led ultimately to what was hoped would provide significant clarification of the law on lifting or piercing the corporate veil. Because in Prest versus Petrodale Resources in 2013, the Supreme Court, for the first time, had the opportunity to look at a situation which involved separate legal personality and potentially allowed an opportunity for them to review the law on lifting the corporate veil. This was quite a complex case. It, on the face of it, didn't involve company law at all, because it was a case on ancillary relief in divorce proceedings. But it involved a husband who was a very wealthy man, and he had a large amount of property which was owned not by him, but by companies that he controlled. And in the divorce proceedings, his wife was seeking to get these properties taken into account in the divorce settlement. And Mr. Prest was arguing that he didn't own the properties were owned by the companies, and therefore they should be ignored from the perspective of the divorce. The court actually found in favour of the wife and held that the properties should be taken into account in a divorce settlement. But the way that they did this was slightly disappointing from the perspective of us lawyers, who really wanted them to give a clear statement in terms of the law on lifting the corporate veil. Because they, in fact, they unanimously agreed that they shouldn't lift the corporate veil. Instead, they said that the companies were owning the properties on trust for Mr. Prest. So they kind of avoided the issue slightly. and most of the Supreme Court justices didn't really consider in any great detail the principle of lifting the corporate veil. However, one justice, Lord Sumption, did consider the issue, and he essentially came up with two situations in which he felt that the courts could lift the corporate veil. And his decision has subsequently been followed in the Gramsby Shipping Corporation case. So what he said was that references to a facade or a sham beg too many questions to provide a satisfactory answer. So he didn't really agree with those cases that we looked at, which refer to the company being used as a facade. Instead, he came up with two principles, as he called them: the concealment principle and the evasion principle. And essentially what he was saying was that if the company structure is being used either to conceal the true facts or to evade potential liability, then in those two situations the courts do have the right to lift the corporate veil and to treat those behind the company as the same as the company. So it's quite a lengthy